if they're giving 100,000 hours of their life to work, it needs to result in them having a better life.
Yeah. And I see the same struggles now that I saw then. There's nothing new under the sun about employment relationships.
At the moment, what's keeping you busy is the good jobs.
Absolutely.
Yeah.
The Good Jobs Employment Rights Bill is probably the biggest single legislative initiative that the Department for the Economy have done in many, many years.
Welcome to the Vibrant Workplace podcast. This is the show where we explore how to build a better working world for both employers and employees. I'm your host, Craig Thompson, founder of Vibrant Workplace, and today I'm delighted to be joined by the Chief Executive of the Labour Relations Agency, Mark McAllister. Mark, welcome to the show.
Thanks very much, Craig. Thanks for having me.
I'm going to put you on the spot to begin with.
Go ahead.
I saw something that you said recently, you're going to be thinking, uh-oh, what have I said? I mean, it really resonated with me. It was, we spend a lot of time on our feet. You need good shoes. You know where this is going?
I do.
We spend a lot of time on our feet. We need good shoes. We spend a lot of time asleep. We need a good bed. We spend a lot of time working. We need a good job. Where did that come from for you?
I have to take credit for it. It's original one, but it just struck me. I mean, we're in the business of work, and we're in the business of working relationships. And my organization has lots of very dedicated public servants who are focused not on self, but on service, about making people's working lives better, because you spend so much time at work. I mean, it is a reality,
Yeah.
You can't escape it. So the quality of the work that people are doing is really important to them, and the quality of the working relationships that they have is really important.
Yeah.
So, when I was thinking about it, how much time do you spend on your feet when you do? And well, you need to be supported by good shoes. You need to be supported by good bed when you sleep so much. And we spend so much time at work. You just need to have good work, and good work in the very broad sense, for what that means, not simply in terms of pay, but all of the other measures that make up what we consider to be a good job. And I know there's a lot of discussion about what is a good job or what is good work, et cetera, et cetera. But over the last year or so, it's become much more clear what that is and what that looks like.
Yeah. That's one of those quotes that I think we'll get that on a graphic. If that was Simon Sinek that said that, that would be viral. So we'll make it go viral after this today.
No worries.
But I think it sums it up really nicely. I do what I do because I remember coming across a stat one time that said that a full-time worker will go to work for about 100,000 hours during their lifetime. And I remember looking at that and thinking, even back to your quote about spend a lot of time sleeping, a lot of people have problems with their quality of sleep and the amount of sleep that they get. They're stressed and they're burned out, etc. There's probably a lot of people who work more than they sleep.
Yeah, absolutely.
And spend more time with their coworkers than they do with maybe their kids and their family. And so I think if you're going to spend that much time working, it's very important that you have a positive experience of the work that you do.
Absolutely. And I mean, if employers, recognize that you do have these work families, you do hear people talking about my work wife or my work husband, because you spend so much time, they recognize that, what does that say about the culture that you need to have in the organization? What are the support mechanisms? What is the nature of the work? What is the level of engagement? How much involvement do you have in decision making? All of these things, because it's very easy to look at work through the lens of pay and get distracted by that. And whilst it is a measure of good work, it's not the only measure, because the things that do keep people up at night, and maybe because they don't get sleep, are not just about pay, but it's also about the quality of their working relationships, or something that they aren't going to have to do at work that they don't feel maybe that they're capable of doing, or something like that.
Like coming on a podcast.
Like coming on a podcast. Absolutely.
But these are the things that, you might be challenged by through work that maybe it isn't in your job description. Maybe it's something you're not prepared to do, you're not trained to do, and all of a sudden you're coming into work, you don't feel supported. Maybe those are the things that keep you up at night. Do you know what I'm really interested in before we get into the LRA and its background, where it came from and what it does? I'm interested in you as a human being, first of all, right? And I want to understand, because I think about this a lot for myself sometimes. I guess what was the point for you at which, because this has been your career, you've dedicated your
Mm.
career to this. What was the point for you at which this really started to resonate and became the bee in your bonnet that made you go, I'm going to dedicate my career to this?
That's good. That's a good question. I suppose back in the early 90s, I was a legal academic, but I was also a trade union official.
Okay.
And I found, like most trade union officials, the demands on me for the trade union part were starting to outweigh the actual ability to do the job.
Okay.
And it became readily apparent very shortly after I became a branch secretary for a trade union that people had lots of issues at work,
Hmm.
you know, and some of the issues that we see now, you know, right, you know, smack up to date in 2026, issues around, you know, workload and work-life balance and stuff like that.
Hmm.
And you were driven by a sense of purpose to try and help people,
Yeah.
to try and make their working lives easier because, you know, you do spend so much time at work. You want people to get the best quality of work because I had witnessed people burning out and people going off on long-term sick and seeing the fabric of working relationships fray. And I thought, I can help in
Mm.
some way. And I suppose that was the inkling in the
Yeah.
early 90s, sort of 1993, 1994. Um, and then that was me. You know,
Yeah.
there were two things that drove me. Was that sense of public service,
Hmm.
that sense of helping people in their working relationships.
Yeah.
And so that was a natural sort of training ground for the work that I would go on to do with the Labour Relations Agency.
Mm.
So I had a background, a legal background, specializing in employment law, trade union official, knew the employment law, then became a regional negotiator for the trade union on a Northern Ireland wide basis,
Yeah.
and then joined the Labour Relations Agency. So it was a natural fit
Mm.
for me in that regard. And you know, I know it's cliche, and people say, you know, if you love your job, you'll never do a day's work in your life. I don't think it's too too unique to say. I don't. I've never worked a day in my life because I love my job. I love my job.
You need to set your own business up. You'll know all about it. Because
Yeah.
I look at that quote sometimes and I go, I get it. I absolutely love what I do. I'm very passionate about it. But wow, has it been difficult in recent years, being self-employed during the pandemic and
Yeah,
things like that.
absolutely.
So I work hard, but
Yeah,
I love it. And I absolutely agree with it matters and it's worthwhile
yeah.
when you're doing something that you care about. But there must even be a seed before that for you because you you got involved with a trade union.
Hmm.
So even before that,
Yeah.
what was it? There must have been a seed. There must have been a point. This
I
At
think.
some point this became really important to you to even want to get involved with a trade union.
Yeah, no, I think it was. I wasn't prepared to be a passive bystander when I saw what was happening with people around me who were well qualified, good at their job, but were struggling.
Yeah.
And you know, it was maybe a struggle with workload or a struggle with relationships, whatever. And I see the same struggles now that I saw then. You know, there's
Yeah.
nothing new under the sun about employment relationships. You know, whether it's, you know, people craving a work-life balance or people suffering from bullying and harassment or people not feeling disengaged, etc., etc. Those same issues that I saw in the early 90s are the same issues that I see today. And I feel as passionate about trying to help people. Now, I wear a different hat now because obviously I came from a trade union background. When you join the Labour Relations Agency, we have a sort of in-house joke. You go through a process of decontamination
Oh, okay.
where you guard your independence and your impartiality jealously. And although that's what, you know, that trade union and legal background is what got me in the door,
Hmm.
but I leave that baggage, and I left that baggage, you know, in 2000 when I joined the Labour
Right.
Relations Agency,
Okay.
because that then gave me the insight. Because then I got to see the other side from the employer's perspective, and
Mm.
employers struggling to, you know, keep the lights on, the cost of doing business, you know, problems that are weren't of their own making.
Hmm.
And then you saw that dynamic of the work relationship between
Yeah.
the employer and the employee. And that was really beneficial. And we all go through that. Every
Mm.
agency member of staff goes through that. Some people come from trade union, some people come from HR, some people come from management consultancy, some people, you know, come from a legal profession.
Okay.
But once they join the agency,
Yeah.
our core values around being free independent, impartial, and confidential are central tenets, and
Yeah.
we guard those jealously.
So do you have a mix of people then who have come public sector, private
Yeah,
sector, and that
yeah,
gives you, I guess, a team of people who have experienced all the different,
absolutely.
yeah,
And we keep an eye on that balance to make sure, yeah, to make sure that our workforce has that relevant balance, so that they will bring that small business experience with them, or they'll bring that big
right,
private sector HR, or that public sector trade union
yeah,
background. And that diverse pool of talent is fantastic for us, because people will draw on that and say, well, look,
yeah,
there's a collective bargain on this, or there's a
yeah,
JNCC here, or there, or that relationship's very personal. All of those insights are really, really valuable to us.
yeah, okay. And I think it's very important that we start from that position, because it's got to work for both parties. It's got to work for employer as well as
Yeah,
employee, and it's got to work for employee as well as employer. And it sounds obvious, but I think sometimes it would be beneficial for people to have run their own business
yeah,
in order to understand just how difficult it can be and the challenges that go with it. There's got to be a business at the end of everything that we do to keep the lights on and
yeah,
keep employing people
yeah,
and offering these jobs. But at the same time, everything in business, when it comes to, the commercial side of business and private organizations, everything's about return on investment.
yeah.
Okay. There has to be a return on investment for the employee as well.
Yes,
You know,
absolutely.
we talked
They're your
about
biggest. They should be your biggest investment.
exactly.
Yeah,
But if they're giving 100,000 hours of their life to work,
hmm,
it needs to result in them having a better life.
yeah,
I always think that if someone hates their work and they have a negative experience of work,
yeah,
it's going to be very difficult for them to have a happy life, because you go home, you spent the whole day in work, stressed out, operating at burnout, in conflict with people, you're in a bad mood. Your partner says, how was your day? Wishes they didn't ask the
yeah.
question.
No, no. We see that because
Yeah.
you don't leave. You don't. And I suppose, and after COVID, we saw that people took a different perspective on their working life.
Okay.
A lot of people saw that, what would have been considered to be traditionally within the realms of their private life became merged with what their working life. And that has it's a
Yeah.
double-edged sword in that regard.
Yeah.
So we saw a massive increase in work around equality, diversity, and inclusion.
Yeah.
But then we saw the culture war backlash against that, and the whole notion of bringing your whole self to work, and, and,
Right.
and all of those things. And it,
Yeah.
it really exposed how there was this inflection point in the world of work post COVID, where people had a different approach to work, and meant that they didn't leave all the personal baggage at home, because it seeps into their personal life.
Hmm.
If someone's
Yeah.
being bullied and harassed at work, that their feelings about that doesn't shut down at 5 o'clock. They bring that home, and that affects how they impact on. And so when people come to the Labour Relations Agency, we never get them on their best day.
Yeah.
Invariably, they
Okay.
come to us when the treatment, or the disengagement, or the pay, or whatever the nub of their issue is,
Uh-huh.
has reached a point where they have to reach out and
Yeah.
say to us. And that, one of the beauties about the agency is, it's fresh eyes.
Mhm.
We come to it independently and impartially, and we will give a fresh perspective on it. But the difficulty is, many people arrive too late,
Mm.
and that's why, back in the 70s, the LRA would have stood for the last resort agency, because everything had gone completely pear-shaped at
Never
that
heard
stage.
that before, right?
And we were expected to engage in what was a de facto salvage operation. But
Okay.
those working relationships were broken.
Yeah.
They were beyond repair.
Uh-huh.
Tribunal cases were pending, and we may have got a settlement. That didn't repair the working relationship.
Okay.
That simply stopped the case going to the industrial tribunal. And I suppose that's one of the things about how the agency's developed. We were formed 50 years ago in 1976.
So it's the big
It's
anniversary.
the big birthday. It's
Yeah.
big half a century. And it's really important to us, because we have been serving the world of work in Northern Ireland for 50 years.
Uh-huh.
But the way we serve it isn't the way we served it back in the 70s. You have to remember that the legislation that set us up talks about apprehending a trade dispute, and the language is very industrial, and it's a product of its time.
Okay.
It's about strikes and walkouts and wildcats and stuff like that. Not relevant to the same extent as it is now.
Okay.
You know, so there is now much more focus on dispute prevention than there is on dispute resolution.
Yeah.
But you still get the disputes. And the key issue is for people to come to us early enough so that we can mend the fabric of that working relationship and prevent it going any further. And that's
Yeah.
really, you know, that it is turned on its axis over the last 50 years. But we still have disputes and we still have strikes that we need to resolve.
So from what you're saying then, is it better for both employer and employee if they engage you earlier?
Absolutely.
Yeah.
But we understand that there's sometimes a reluctance, especially on employers' part,
Okay.
to get a third party involved. Okay. And that can be sometimes down to misperceptions about what the agency is there to do. We aren't an enforcement body. We're there to try and facilitate the resolution of a dispute in a relationship. Lots of employers, especially small employers, will want to keep things in-house, not do their dirty laundry in public. You know, there are perceptions about that and fears about losing control over how that relationship should be resolved. And I think a lot of that's based on misperceptions, you know, because they think, well, I lose control, whatever. We don't enforce. If we can help inform decisions. If you make a bad decision, you live with the consequences. We don't make there's no enforcement
So
over
you're
that.
not, are you telling that you're not telling them what to
No.
do then? You're,
We inform their decision-making process to say, okay, this relationship's broken down this way.
yeah.
You could consider A, B, C, and the advantages, disadvantages are da, 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 da. But ultimately, there's a case lodged at tribunal, and it may result in a hearing or whatever. And so the employer has to make decisions, you know, based on the facts in front of them.
Okay. And you've obviously got so much experience of being involved in these situations where I guess, you know, an employer may not be dealing with that on that scale every single day.
Definitely not.
You are?
There's employers out there who don't know we exist or don't know what we do or have misperceptions about what we do. And we find ourselves constantly battering against a narrative. Sometimes you get the LRA involved and it'll not go your way.
Okay.
And some employers have been burned because they've had a bad experience in an industrial tribunal, and it colors their view going forward about everything to do with employees and rights and entitlements and all of that. You know, so there's very little sometimes you can do about that because so again, some of the organizations we have, you know, will know exactly who we are and what we do, but lots of other organizations don't. And we do constantly try to keep the message out. This is what we do and this is what we don't do. And this is how we can help and what we can't do. And that takes time. And we've been working at that. We've been working on that for, 50 years now.
I'm trying to put myself in the shoes of, let's say, you know, a small business, 30, 40 employees. And something that's coming into my head is I might be wondering if I went to the LRA about conflict that I've got with an employee, might it suddenly become something bigger than it was? Or even if that's the perception that I have, might I not understand the benefit? And might I think, let's just deal with this in-house, it'll be easier because it might become a thing?
No, I think that's a very valid point, and it depends on what the employer is looking for. So if a working relationship is going south and really bad, but it hasn't resulted in a formal grievance or a tribunal case, there's nothing to stop an employer doing their due diligence and looking up and saying, well, how would mediation maybe help? Check what's involved, and our information's on our website. It's free of charge, etc. And they can read exactly what's involved. That doesn't always bridge the gap between the culture of bringing a third party in. It's a construct of letting somebody else into our world, and then thinking, do I lose control over this? And that there is definitely a problem for that. But time and time again, we see it, Craig, because employers are trying to get resolved, and they can't see the wood for the trees. They're too closely involved. It takes that third party, that honest broker to come in and say, okay, let's look at that. And then some employers are worried about the fact that levels the playing field because the power dynamic is different, because we don't go in and say, okay, well, look, the employer's in a better position here and we have to respect them. It's not, we completely level the playing field because that's a natural outworking of our independence. And some employers don't like the fact that the playing field has been leveled. And so there are issues there. So, there are a host of reasons why employers either wouldn't want to use us. But it's about educating them to let them know, say, well, that's not what this involves. Some employers, there are good employers and there are bad employers, and there are good employees and there are bad employees. And a lot of this will speak to the culture of the owners of the organization
Yeah.
and what their past experiences have been with employees. So if you have someone who has taken a completely unmeritorious claim to the industrial tribunal and the employer has settled to make it go away, that will mark them. That will legacy will be left with them to say,
Yeah.
employee there was swinging the lead and took me for money, and I resent that. And in other instances, you know, where an employee has genuinely been treated badly and does go to a tribunal, and you know, it is covered by the media in the back row of the tribunal office, and it's in the headlines, and the employer had a case to answer, but didn't address it early enough. So there are cases on at either end of the spectrum, you know, and I think it's about employers proactively making themselves aware of what could happen. You know, it's not just about procedural correctness of grievance procedures or discipline procedures.
Yeah.
It's about knowing your people.
Yeah.
It's about knowing your people.
I think sometimes the employee who feels disgruntled over something, even if it hasn't yet reached the stage of a grievance, they may, I guess, having an independent party who comes in, like they may never feel like they're part of a fair mediation if, you know, the mediator is someone from within the company who is pretending to be neutral because they're still connected to the company. So having that independent third party coming in might make the employee feel more like, okay, this is now a fair conversation. I'm prepared to engage in this. I'm prepared to work with them.
Yeah, absolutely. And the mediation process, the mediator will, you know, voice the strengths and weaknesses of their case in order to frame their situation and say, well, look, there may not be a case to answer here, or it's pretty you know, weak or whatever, but ultimately they have to make the decision. And it's about trying to find out the interests, and I don't mean the hobbies, but the interests of the parties, to try and narrow the gap to say, well, what will resolve this for you, you know. And then it's about expectation management. It's about making sure that that relationship will be able to return to a positive working relationship. So the dynamic in mediation is really good. I mean, as a qualified mediator and an experienced mediator, there's probably no feeling in the world like getting a dispute resolved through mediation, an interpersonal dispute.
Yeah.
It's fantastic. It's an electric feeling. There's a great sense of job satisfaction from it, you know. But ultimately, it's incumbent on the people to come to us at the right time.
Yeah.
You know, I remember, anecdotally, I remember one of the first mediations I did many, many years ago, and it was in an organization in the public sector, and I took the phone call and said, right, okay, and one of the manifestations of the breakdown in the working relationship was that the employee ate their lunch in their car.
Okay.
So they didn't have their lunch in the staff room, but they had it in the car. And just before I put the phone down, just before I was driving, I just said, how long has he been eating his lunch in his car? And they said 12 years. And I knew straight away that we'd been called too late, because that working relationship had fundamentally broken down. The implied duty of trust and confidence between the two parties was ruined. And so mediation wasn't going to work. It's not, you know, it wasn't the silver bullet. I didn't have a magic wand. That was never going to work. So, you know, whilst it is vaunted quite rightly as being a great alternative dispute resolution mechanism, there are lots of variables, and the timing is one of them.
Yeah. Okay. So how does it typically get to the point where it reaches you? Is it the employee coming directly to you, or is it through unions, or what? Is it the employer that comes to you?
Our organization deals with somewhere in the region of between 12 and 15,000 calls a year. Okay, to our workplace information.
You're busy now.
We're busy. We're busy. And the split is pretty 55-45 employer-employee. That's sometimes trade union official or employee,
right?
Or it'll be HR consultant and or business owner.
Yeah.
Okay. And so those queries come in. And sometimes those queries will manifest themselves in, next thing there's a grievance, and next thing there's an early conciliation claim, and next thing there's a potential tribunal claim. So you can follow the journey sometimes through from the phone call right through to the tribunal case. And that in that intervening time, we have a legal duty to try and resolve that dispute before it goes to the tribunal.
Yeah.
So invariably, we have no control as a reactive service about when they come to us.
Yeah.
That phone call might come too late because the early conciliation notification's coming in the next day, and 2 weeks after that, it's listed for hearing on a tribunal and whatever. We don't have any control over that. We will say to people generally, make sure you come to us early if it's appropriate.
Yeah.
But we'd much prefer you have your own house in order and resolve it internally.
Yeah.
So a lot of the things that we have involved in, for example, developing the postgrad in Ulster University in employment law and ADR practice, is about building capacity out there in organizations so that these issues can be resolved, early, nipped in the bud early by people who know what they're doing. And that skill set. And it's a really, really important skill set to have. But so many more still come our way.
Okay.
It's a reactive service. So, that can result in anywhere between 6,500, 7,000 industrial tribunal claims a year, which is a lot. And, and then sometimes you have a case decision that comes along at a superior court level that means that there's a raft of cases coming in.
Yeah.
For example, pension cases, we have somewhere in the region of 44,000 pension cases, injury to feelings cases that are on our books, and holiday pay cases. Holiday pay cases are lodged every 3 months as an ongoing unlawful deduction from wages. So we have somewhere in the region of 285,000 holiday pay cases sitting good. And that's only 2 jurisdictions. You have all the rest, the unfair dismissal, the discrimination, etc., etc. So there is a massive body of work to do there in that regard. And that's the dispute resolution part.
Yeah.
And I want to get away from that part and focus on the dispute prevention, because if you get the prevention right, the resolution will resolve, it won't happen. So there is a pivotal shift in terms of my vision in the agency towards that dispute prevention, so that we're not so reliant on the dispute resolution, because by the time you go to tribunal, the relationship's ruined.
Yeah.
The key is in the name, labor relations. And if you're in tribunal, end of relationship.
So as you said, the key's in the name, labor relations. I keep thinking about all the different bodies that are out there. And, I was thinking about this recently and thinking from an employer's perspective who's just in the grind, doing the job, so focused on keeping the lights on, etc.
Yeah.
And you've got the LRA, you've got the Employers Federation.
Yeah.
You've got, obviously, the Federation of Small Businesses.
Yeah.
You've got the CBI.
Yeah.
You've got all these different things, right?
But all different functions.
But that's what I want to know is from their perspective. So the LRA then, what is the unique differentiator? What makes you you as opposed to?
We are a non-departmental public body, or an arm's length body, or what would have been called in old money a quango. So we are a public sector body with the statutory responsibility for improving employment relations in Northern Ireland. Okay. And that's everything from advice to research to resolving disputes through conciliation.
Yeah.
So we're a public service. The Federation of Small Businesses is an employer's representative body. They lobby on and provide services on behalf of their members. The Employers Federation is exactly the same. They would have been traditionally engineering employers, but they've widened their scope out now. So they're employer bodies. So you have Federation of Small Businesses, Employers Federation, Manufacturing NI, CBI Northern Ireland, Institute of Directors Northern Ireland, Northern Ireland Chamber of Commerce, and you have all of these bodies. You probably have somewhere in the region of around 10 employer-based bodies,
right?
All representing their members' interests, and that's in terms of lobbying, services provided, insurance, advice, whatever it happens to be. But they are representative of those members, their membership bodies. Whereas the agency is a public service to everybody.
Gotcha.
So those bodies will come to us as customers, and their members will come to us as customers, and their employees will come to us as customers.
Yeah.
But we're completely different from that in that regard. So you have those employer bodies, and I'd say there's maybe sort of half a dozen, seven of those. And on the other side of the equation, you'll have the Northern Ireland Congress of the Irish Congress of Trade Unions that represent all the trade unions. So that's NIPSA, GMB, Unite, SIP2, and all the other trade unions. And so those are well recognized as being probably the two big parties that represent the working relationships in Northern Ireland, but from different perspectives. Employers, employees, and us in the middle.
Your job then is to sort of bring it all together.
And we do that. We have we have a body called the Engagement Forum in Northern Ireland,
Yeah.
which effectively facilitates discussions between those very groups, the trade unions and the employers' bodies, around big ticket items like,
Yeah.
we were formed
Yeah.
in COVID, and we did things around COVID around, the essential workers list and the emergency code of practice for safe working.
Mm-hmm.
But we retained our identity after that because we saw the benefits of what we could do. And now, obviously, the big ticket item is the Good Jobs Employment Rights Bill.
Yep.
And we have that forum still facilitated, and we have Chatham House rule based discussions around the various parts of the bill, et cetera, et cetera. And that is a really, I think it's an essential vehicle for looking at the whole construct of what we call social dialogue.
Okay.
So we have the big bodies, the big beasts in the employment relationship who will speak and say, we have an issue with this, or
Yeah.
we don't want to see that, or we would like to see this. And they can do that in a safe space so people will know where they are on various things, but they'll also start forming relationships, and they'll also start forming bonds and trust. And that effectively becomes a form of what I call social partnership like.
Yeah. Okay.
Where they can have those discussions without fear of it being represented in the media or talk to outside the room. And that's really, really important because, small employers will recognize that trade unionists don't have two heads, and they're not always, the body in the picture. And that's really, really important. And we facilitate that as part and parcel of our general raison d'etre, which is the improvement of employment and industrial relations in Northern Ireland.
Right. So in that forum, employers themselves, are they in the room, or is it's the body?
It's a representative body.
Yeah.
Because if it was the employers, it'd be the cast of thousands.
Exactly.
So the
That's what I was
FSB
wondering.
represent the sort
Yeah.
of the micro employers. Chamber, obviously slightly bigger. IOD would be people at the top echelons.
Yeah.
Manufacturing NI in terms of big
Yeah.
sectors,
Uh-huh.
and so they're represented there in
Okay.
a manageable group.
Makes sense.
Otherwise,
Yeah.
you're herding cats.
Exactly.
You just can't
And
control a group that size.
the rule that you mentioned, just so I picked that.
The Chatham House rules, the international. So in other words, what's said in the room stays in the room.
Ah,
There's
okay.
there's no discussion that says, the employer said this and suddenly that's out in the public domain.
Yeah.
The Chatham House rule is essentially a confidential conversation.
I think you must need something like that to have the conversations that really need to be had.
Exactly. People won't
Yeah.
engage unless they know what they're saying. And that's predicated on trust. And that trust develops. So when COVID hit, and we were asked by the executive office to facilitate those two very big pieces of work about the essential workers and the emergency safe working code of practice.
Mm-hmm.
We did it. The employers and the trade unions sat together as if they worked side by side
Is that right?
for years.
Okay.
I know I was involved in facilitating one of the groups in that with regard to and we worked over weekends and nights through COVID remotely and emailing draft documents and saying, what do you think of this? And people would comment back. And we had a deadline, and the TO, the executive office, were impressed that, in a crisis, these bodies came together and they produced the results.
Yeah. So it shows what's possible.
It shows what's
Done right,
possible,
yeah.
but it shouldn't take a crisis to make it possible.
Yeah. Yeah.
COVID was a common enemy at that stage,
Mm-hmm.
but now, the key issue is, can we work together on issues where there isn't such a common enemy?
Yeah.
Can people work together and say, look, I agree with parts of that, but we disagree in parts of that?
Yeah.
That's negotiation.
And when did the forum start?
Oh, the forum started shortly after COVID hit. Prior to that, we had what was called the Northern Ireland Employment Relations Roundtable.
Okay.
And it was an early precursor to that.
Yeah.
And then it converted and increased the membership size during COVID.
Right.
But then we reduced the size, but continued on after COVID because of the success of it.
Yeah.
So it has been around in some shape or form for around 20 years. It's just changed guise.
Mm-hmm. Okay. So we need to talk about the Good Jobs Bill. Just before we do, you're in the LRA, isn't it, about 25 years?
25 years in October past.
And it's obviously 50-year anniversary. So you're there half that time. You've seen a lot of change.
I have. It's a fantastic organization to work with, and the people that I work alongside are amazing. They are people who will put service before self. Everybody gets, if you walk into our office now and say an individual employee, what are the four values of the organization? Every one of them will be able to say progressive, ethical, exemplary, and responsive. And what are our core operating principles? Confidential, impartial, independent, and free.
Very good.
So,
Yeah.
that's ingrained in our psyche.
Yeah.
Whether you came from a trade union background or a HR background, or you were a lawyer, or you were a management consultant, or whatever it happened to be. And to work with such talented people makes a day a dream. Like, I mean, people talk about, the way they talk about Sunday scaries, about, going into work. Don't have that. You're going into work with great people, talented people. And so I've had the pleasure over the past 25 years of working with I've seen a lot of people come and go. But there's always been that consistent level of public service. That's what drives people. It is that notion of public service. And I know when you hear headlines on the Nolan show and places like that, and public servants get a hard time, working from home, and like, that does not reflect the reality. The reality is I work with people who are vocationally driven to make other people's work good.
Must be difficult too, though. I mean, it makes me think of something that Niall Martindale, the CEO of Connects Energy, said a while ago there. They went through our Vibrant Workplace Accelerator program. Their employees across the 12-week evaluation showed that they had 18.2 times more good and great days at work than bad and terrible days at work. I thought, like, that's the way work can be.
Yeah.
Right? And when I put that to Niall and I said, how is that even possible? He said, it's not that we don't have hard days. We have hard days, but a hard day is not necessarily the same as a bad day.
Yeah.
And when I think about the work that your staff obviously are doing, it must be pretty bloody hard at times too.
It is. We never get people on their good day. You have to remember, we are, for all intents and purposes, we are in the business of workplace conflict. So when we get people who are on the end of the phone, they're not having a good day. They have a particular problem. If we have people coming in for an individual meeting or a conciliation, it's because they have a problem. They're never on their best day.
Yeah.
They're in a bad mood. They're angry. They are, they want some form of remedy.
Yeah.
And similarly, when the employer's coming in saying, I can't believe this is happening. And so our staff deal with negative emotions all day, every day. And we're very, very conscious of that. We're very conscious of that. So we have we have things like in our workplace, we have, mental health first aiders, and we have a room for people to go and decompress, etc. All, to try and make as much provision to help people do their job, because, you can be sure, you talk about a bad day at work. Everybody who you speak to as a customer is having a bad day. And, that, you can't be impervious to that all the time.
Yeah.
So you go home at the end of a week saying, that not all of the negative emotion washes over you. Sometimes it's, you take it home with you, and we're conscious of that. And we look after our staff to make sure that doesn't become a problem for them.
Yeah, understood. So at the moment, what's keeping you busy is the good jobs.
Absolutely.
Yeah.
The Good Jobs Employment Rights Bill is probably the biggest single legislative initiative that the Department for the Economy have done in many, many years, possibly in a generation. There's always been sort of trickles of reform, but as the executive has been in place and then has been suspended and in place and suspended, there have been fits and starts of that. So it's maybe one piece of legislation here, another piece of legislation here. This is a massive, very ambitious agenda that the Minister for the Economy is putting forward, and it relates to our bread and butter, because it's about employment rights. It's about legislation. So I'll be honest with you, I'm delighted and daunted in equal measure.
Okay.
Because it's work that we absolutely should be doing, but it's a massive task. It's the sheer volume of it. There's a lot in it. So the 4 headings under the bill, there's probably about 20 potential, statutory initiatives that fall out of them in terms of employment, pay and benefits, voice and representation, and work-life balance.
Yeah.
So if you take those 4 headings and say there's around 5 statutory initiatives underneath that, some of those are primary legislation, some of those are secondary legislation, some of those are tweaks, some of those are codes, some of them are GB catch-up, what's happened in GB maybe as far back as 8-10 years ago, and some of it's pretty radical. So
I'm going to bring it back to something that you said previously, because I think it's a good question that probably is a bit of an acid test for where this might lead. You took over as the chief exec of the LRA
nearly 2 years ago now.
Nearly 2 years ago, and you've talked about how, I guess for you, your vision and what you're working on is to go from prevention to
No,
sorry, the other way.
resolution.
Yeah.
Oh, you're right.
From prevention.
Resolution.
Resolution to prevention, right?
Yeah.
Is the good jobs bill more likely to help or hinder that?
It's a good question. I think employment legislation resets the floor on certain things. So when employers become aware that the floor has changed and that becomes the baseline, um, that provides a degree of uncertainty for employers, and they have to effectively audit their own practices to say, what will this change mean for me?
Mm-hmm.
So what's probably been happening over the last year, when when the contents of the bill become a bit more crystallized,
Mm-hmm.
employers are going to say, well, look, we do that already. Those first 10 things, that's fine. There's not an issue there. Pay slips and working time, we do all that. So that's fine. It's the unknown stuff that causes the consternation about, oh, wait, we have nothing in place with regard to that or that.
Right.
So what the department have been trying to do over the last sort of year and a half is to engage with employers and the business community and beyond, to say, this is potentially coming down the track. We went out to consultation. This is what you said.
Mm-hmm.
This is what our plan is. And so we have the way forward document now that gives us the sort of template from the department to say, this is what we intend to do. The agency's job is to breathe life into those policy intentions,
Mm-hmm.
and, derive guidance or codes or whatever it happens to be based on what the legislation requires you to do.
Okay.
But until you see what the legislation is actually saying,
Yeah.
there's still a wee bit of uncertainty. So the choreography of the bill, the detailed content of the bill, we haven't seen yet, because it hasn't gone through the process. The drafting will go to the assembly within a number of weeks, and so we will see the start of this passage of legislation effectively.
I think if I was a Danske Bank, for example, with, fabulous HR department and, connections with brilliant employment law specialists, etc., I would probably be.
We've just agreed a pay deal with the Financial Services Union
Is that right?
within the last 24 hours, which is great, because there should be no disputes about pay.
So I guess the point I'm trying to make is, if I was a larger employer, I would probably be welcoming this and thinking, okay, this is great. We've got the resource to know what's going on.
Yeah.
If I was a smaller employer, I might be panicking, because I might be thinking, this is complicated. How do I ensure I keep on top of all this and make sure I'm doing the right things, and ultimately I'm not going to get in trouble?
No, I think that's a fair point. And I think that one of the difficulties is because it's such an ambitious agenda that small employers can't see the wood for the trees. Okay. So say, for example, you're a micro employer, you're a member of the Federation of Small Businesses. What you could do is you can look at the way forward and say, oh, you see those first 12, they haven't really happened in GB. So our members in GB of the Federation of Small Businesses had to cope with that. So let's say, how much upset or cost or, administrative burden was caused by that 5 years ago when you had implemented it? And the answer invariably will, well, no, that's not too bad. It's pretty straightforward. You need to do. And it's about getting your ducks in a row. But the difficulty is, context informs everything. So small businesses have been hit with national insurance contribution increase in the national living wage and the real living wage, and they therefore just see the cost of doing business. And if all you can see is the cost of doing business, then you're in survival mode, and all the rest is just noise. And then it becomes, the perception is, there's far too much in that for me to deal with, and the shutters come down. And that is not a good strategy, to just ignore it, and hope it'll go away, because the reality is, once it starts its passage to legislation, there's a very good chance that it will happen. There's a slight chance that it might not happen. But if it does happen, burying your head in the sand isn't a strategy.
What's the expression? What you don't know can't hurt you, but it can.
Ignorance is bliss, but ignorance of the law is no excuse.
Yeah. So how should employers prepare themselves? I'm thinking particularly those smaller employers. Look, before this conversation, and in general in recent weeks and months, I've been reaching out to lots of employers to ask them, what do you know about this? And what do you think about it? A lot of employers, when I mention the Good Jobs Employment Right Bill, the eyes glaze over and they go, what? The what? So there's a lot of them that don't even know it's coming.
I think the difficulty is you will have lots of employers who will fall between the cracks. I mean, we have a private sector economy that's effectively micro employer based. Not all of those employers are members of the Federation of Small
Yeah.
Businesses or the small part of the chamber, or whatever it happens to be.
Hmm.
So there may be a genuine lack of awareness that this is coming down the track. And there's no small employer exemption to any of this. I mean, this
Hmm.
will apply.
Yeah.
Um, across the board. So I think the question is, levels of engagement are, you know, sometimes what happens is there'll be a conversation a small employer will have with their accountant, and the accountant, because they do lots more than just the books at
Yeah.
the end of the year, say, look, we're aware that this is coming down the track.
Yeah.
Are you ready for that? And they'll go, no. Well, you'll maybe. So it's who that essential first point of contact is,
Yeah.
because micro employers with 10 employees or less are looking at tomorrow and keeping the shutters open,
Mm.
or seeing
Yeah.
what their rates bill is,
Very much so.
or
Yeah.
see what the supplier increased costs are. We understand that, absolutely. But it's not an option just to say this, that's not important enough for
Yeah.
you to look at, because this, if it does happen, they will have to be ready, and they
Yeah.
will have to. Now, the difficulty is we've no idea what the sequencing is going to be. So how much of this is going to become, law in early 27, possibly into 28.
Uh-huh.
How much of it will be regulation based on further regulation that, it's what's called an enabling power.
Yeah.
So the legislation gives the power for regulations to be made at a later stage.
Mm.
So it's very difficult to see, with regard to the sort of 20 odd areas of reform, what the choreography in terms of the timeline is going to be,
Mm-hmm.
because some of it's going to have bigger impact than others.
Yeah.
And when ministers and the government officials are working together, they will have and be attuned to the ability and the need for employers to absorb the economic impact
Mm.
of legislative change. And so you rarely find that the big sort of, massive headline changes come straight away. It's the quick wins in terms of the GB catch up to
Right.
get people socialized to the idea that you're just going to have to play catch up here, and you're going to have to make these administrative reforms, blah, blah, blah.
Yeah.
So simple things like, the requirement to have pay slips. Vast majority of employers go, we've done that. Changing the reference period for holiday pay calculation from 12 weeks to 52 weeks. That's happened in GB several years ago.
Uh-huh.
Most people have got that in place now, and it irons out those peaks and troughs and overtime, and so makes holiday pay calculation much more easy.
Yeah.
So you'll find that there are quick wins and easy fixes and easy compliance issues within the bill. And later in the provision for legislation will come the hard yards, the big ticket issues. And obviously some of those are very, very emotive and speak to the business model that they have. It's regulation of 0 hours contracts, and you rely on 0 hours contracts. The difficulty is there has been evidence in the past of exploitation of 0 hours workers, or last minute cancellations of shifts. And if your business model is predicated on a workforce who are all on 0 hours contracts, this is going to have massive ramifications for you.
Okay. I think something that strikes me as big concern or risk here is you don't know what you don't know. So if you're a small business owner, and as you mentioned, you're focused on survival, and you've got no idea this is coming, and all of a sudden you find yourself 6 months down the line, having done something that was the wrong way, but you didn't even know about this. How can we ensure that these employers do know about this?
I think that's where my organization comes in. Like, we've done podcasts and advisory material on, preparation for the Good Jobs Bill. Not in big detail, because we don't know the detail yet, but in the broad areas, heading areas, where an employer can sit in the comfort of their own home, listen to a podcast and go, oh, right, I need to maybe be getting prepared for that. I need to get prepared for that. I need to get prepared for that. And it's about having that, it's not a case of you don't know what you don't know. It's now I know that something has to be done. And that's where my organization and other organizations can help and say, you need to do X, Y, and Z. So if you're a member of an employer's body, like a business trade guild or a body like that, that's one of their roles, is to keep their members informed. But if you're not, then you can come to us and you can get the information for free, and we can help you. But we don't provide the same services. So we're totally, as you said earlier on, we're totally different body than those bodies. Member-based bodies, you pay an annual subscription and they will help you with X, Y, and Z.
Right. you would hope, because I think a lot of small organizations, don't have in-house HR, for example. You would hope the HR consultants or companies that they engage, or employment law specialists, etc., are proactively giving them a nudge
Yeah.
and go and make sure you're ready.
Yeah.
It's,
But the question is if they're members or not, or are they touting for business on the basis that you're not a member of ours, but do you know this
yeah.
is coming down the line?
Mhm.
That's a business model that HR consultancies use. I mean,
Yeah.
that's
Yeah.
perfectly acceptable.
Yeah.
The question is, it's pretty hard to ignore headlines in the media. The minister's been on the news talking about the Good Jobs Bill. There's different things coming out on websites, Invest in Northern Ireland, places where businesses go to seek
Yeah.
funding, where you can see that this is so, to say that you're completely oblivious to the Good Jobs Employment Rights Bill,
Yeah.
it's pretty hard now, because this has been published and publicized for
Yeah.
the way forward document's been out for months now.
Yeah.
So the question is, are you willfully sort of turning your head away from it?
Yeah.
To say, look, this is going to have effect on me, but I'm
Yeah.
just ignoring it until I have to, because many small businesses operate like that. It's what's in front of your nose
Exactly.
at the minute.
Yeah.
And if it's what's in front of your nose is keeping the lights on,
Mm.
then the Good Jobs Bill is probably not a priority for you.
Mhm.
But if you leave it until you're not complying with the law,
Mhm.
then that becomes a problem.
Yeah.
So I understand that people will leave it and leave it and leave it till the last minute. But the difficulty is, the longer you leave it, the more it's going to cost.
Yeah.
The higher the risk
Yeah.
of non-compliance with the law.
Uh-huh.
And then you're into, employees then saying you're not complying with the law, and
Yeah.
they have a grievance or they have a tribunal case against you.
So, in terms of the background of this, because obviously it's not, the LRA hasn't created this. For people who are watching or listening and they're thinking, where did this come from? Why did it come about? Why is it necessary?
I mean, this is obviously Conor Murphy, who was a minister for the Department of the Economy. This was effectively an initiative that came through him and the Department for the Economy to say, look, when we talk about good jobs, we need to see that it's a combination of both legislative measures, but also some other initiatives in terms of guidance and best practice, not simply about pay, but under these measures of what constitute good work. So when you look at the bill, it's in terms of terms and conditions of work, pay and benefits, voice and recognition, and work-life balance. So if you take those 4 areas and look at the reforms under each of them, they're about raising the tide of the quality of the work, so that people aren't on exploitative 0 hours contracts, that there should be a commitment to paying the real living wage, and all of the sort of measures that make a good job. You're more engaged in decision making. You have someone who can speak on your behalf and voice and representation. You have the ability to make a flexible working request.
Yeah.
All of the measures. So this is an ideological premise for improving the quality of work across the board. So a high tide floats all boats. And the manifestation of that is the Good Jobs Bill. Some of that will come from legislation, and some of that will be good practice. So it's and from my perspective, the Labour Relations Agency's perspective, and I've said this before, people fall out about 3 things generally:
Okay.
pay, policies, and people.
Okay.
So when you take the Good Jobs Bill, every part of the Good Jobs Bill and the measures of good work will fall into the category of pay, policies, or people.
That suggests there could be a riot coming.
No. What I see is that if you get the pay, the people, and the policies people right, if you get that part right, then the chances of being disputes is limited.
Okay.
And then we can focus on the preventative stuff.
Yeah.
So the underpinning logic of good jobs, not just the bill, but good jobs, speaks to improved employment relations, because you're improving the things that people fall out about the most. So it's a natural fit for us as an agenda, but we don't have say in the policy. We don't have say in the legislation. We simply breathe life into that when the lawmakers and the policy officials do all of their work.
Yeah. And you're there as a source of support. For organizations and for employees. And when I've spoken to organizations to try and ask what their opinion on this is coming up, I'm either hearing the what, right? They don't know about it, or I'm hearing the same response time and again from those who do know about it, which is by and large happy with it, because I think most people, you mentioned before, there's good businesses, there's bad businesses in terms of employers. There's also good and bad employees. I think broadly, most organizations, the opinion that I'm hearing is, yeah, this is pretty good. We do most of it.
Yeah.
Happy enough, right? The one area where I'm hearing, and you probably know this is coming, they're going voice and representation. They're not using that word. They're going unions,
Yeah.
right? And they're panicking.
Yeah.
Now, I have had heads of people and culture, HR directors, company owners who are saying to me things like they have felt bullied and humiliated at times over the years
Yeah.
in their engagements with unions,
Yeah.
and they're panicking and they're worried. And some people have said to me in advance of this, should we not be fixing the dynamic and the relationship between how unions and employers engage
Yeah.
first
Yeah.
before making changes? What's your thoughts on that?
It's a point well made, and I think at this stage it's probably well known that the business community, both large and small, are worried about the trade union access and the trade union recognition threshold as part of the Good Jobs Bill. Largely because they maybe have a fixed idea about working with trade unions, or they've had a bad experience, or they know somebody who's a bad experience with a trade union, and so they have this sort of closed mind to it. And you're right, a lot of that maybe has been where someone has had a really bad experience. And one of the component parts of the bill is for my organization to draft a code of practice about behavioral governance and working relationships between employers and trade unions, about, even stuff. And it's interesting, we talk about capacity and capability. Like, if you say to some professionals, right, show me the demarcation between what you inform about, what you consult over, and what you negotiate about,
Right.
they find that difficult. The demarcation lines are very different.
Yeah.
So what we will want to do is we are hoping to draft a code of practice to say, here's the thing, this is what collective bargaining is, this is information, this is consultation, this is negotiation.
Yeah.
This is how you should behave. It seems trite to have to say, how to behave yourself in a meeting with a trade union, but there are behavioral expectations that are not always expressed in writing. So if we have a code of practice to people to be able to say, look, that behavior is unacceptable, it's in breach of the statutory code.
And that's for both sides.
That's for both sides.
Right. Yeah.
And that will put a bit of governance framework around the relationship and put a bit of manners on people's behavior in the room. And that's no bad thing. That's no bad thing.
I think that would give a lot of confidence.
It would. The bigger problem is not so much the code and the acceptance of any code. It's the construct of trade union access into small businesses that some employers are worried about, really worried about, because they've never operated with a trade union. Some employers say, look, we don't need a trade union. We inform and consult our staff directly. We have low levels of grievances, and we pay our staff well. So what's the need for a trade union?
Yeah. So that,
yeah. But on the other side, you have some employers who are undercutting and maybe not doing what they should be doing.
Yeah.
And then as a result, that paints employers in a bad light. And trade unions say, we need to get in there and organize in order to protect the people who are working in there, because they're either vulnerable or they're subject to some form of, poor treatment, or whatever it happens to be.
Yeah.
And the difficulty is, for you have all of these good employers, but you also have these bad employers. So the legislative floor looks like it's a sledgehammer to crack a nut.
Okay.
But the reality is, raising the legislative floor as a minimum will expose the bad employers, and then they will have to comply. After that, it's about good practice, and it's about relationships. But the trade union access is a cultural thing. Legislation is a very blunt instrument to affect a cultural change.
Yeah.
So if you've been working as a small manufacturer in Mid-Ulster, and you've 40 staff or 50 staff, never had a trade union near your door, and suddenly the law changes and says, based on the model that operates for the past 25 years in New Zealand, for example, the trade union can come to you, and within X amount of days, you have to let them come on your premises to organize, or, get, do the groundwork for recognition, or address a health and safety issue, whatever it happens to be. That's a massive cultural change for the employer. And you can see, hold on a second, why are we doing this?
I think they're worried because it's the sensational experiences that get talked about.
Yeah.
And I want to be fair and say that most employers that I've spoken to have said, when you get a good union rep, it's transformative.
Absolutely.
But what gets talked about is the bad one.
Absolutely. And this is the thing, when You have a recognized trade union and you have a good working relationship with both the lay official and the full-time official.
Mm.
The time, money, and effort saved on things like negotiation, pay, or terms and conditions, or
Mm.
health and safety, or employee learning, or
Yeah.
equality
Yeah.
is phenomenal because they add that value.
Mm.
A good trade union adds value to the organization.
Yeah.
The difficulty is employers have heard scare stories
Yeah.
or know somebody who's had a bad experience, and so the shutters come down.
Yeah.
And that, look, I don't think that's ever going to change.
Uh-huh.
So, but it's easily the most contentious part of the Good Jobs bill
Yeah.
because there's a fear of the unknown.
I think that we have to say as well, because it's easy, the very mention of the word union
Mhm.
brings up negative connotations
Yeah.
for a lot of employers, and but we also have to think of a lot of the rights that we have today wouldn't exist.
Yeah.
I mean, what kind of society, what kind of working engagements would we have
Yeah.
if we didn't have the things that were fought for? So they have to have their place, but the way that it happens
Yeah.
is very important.
Yeah.
And I think what you're talking about there in terms of codes of practice could be very important for
Yeah.
that. There is so much more that I want to dig into about all of this. I do want to say, just to those who are watching and listening, we are going to run an event in
Mhm.
May, and Mark's going to come and speak at it.
Sure.
We're also going to have Michelle McGinley from the Employers Federation, Susan Heyman from the CIPD, Barry Taylor from Mega, and just waiting on, final word back from a couple of other stakeholders as well who should be coming to speak. But looks like it'll be May 28th. If this sounds like it's a complex topic for you, which it probably is, and there's more that you want to know about it, come to that event because that's the place to come, hear from these guys, understand what it's all about. If I was to sort of come towards a bit of a wrap up with this, because again, this could be like a 3 hour feature length movie that we could do on this, but um, if I'm an employer who's watching or listening, what do you think are the things that I should be most focused on in preparation?
I think, it's very difficult to say without knowing how far along employers are around things like, pay slips and some of the quick win stuff. So what we would be saying to most employers now is take a look at the way forward document that the Department for the Economy have published to say this is what our intention is. Take a look at the 4 areas and audit your own practice against what the intention is. So for example, if you don't use 0 hours workers,
Yeah.
that component's gone.
Yeah.
If you already pay people or provide them with pay slips, that component's gone. So you can actually go and tick through the various 20 initiatives and say, already covered, already covered, already covered, doesn't apply to me, doesn't apply to me, doesn't apply to me. And suddenly then you'll be able to boil that down to say, okay, there are probably about 8 things here that we need to change. We're not sure of the timeline, but let's see which ones are the easiest to do first and the quickest to do,
Mm-hmm.
and work it that way, because there isn't one size fits all, Craig.
Yeah.
The difficulty is different employers are further down the track because they've maybe got advice or they're part of a guild or they've spoken to our organization or whatever, and they've been given a heads up on it. So I think the best thing to do is look at the way forward document from the Department for the Economy's website on the Good Jobs bill.
Okay.
Look at those 4 headings, look at the subheadings within it, and audit your own practice against what the intention the intention is.
Yeah.
Some of it you'll not be able to do anything about because, for example, trade union access,
Mm-hmm.
if that happens, you react to that.
Mm-hmm.
So you can't be proactive unless you think, okay, well, I'll recognize Unite now
Right.
preemptively
Yeah.
because they've been knocking at the door for a while and whatever. But again, context informs everything. So some employers might have 50 employees, 30 of them pay a direct debit privately to Unite as
Yeah.
a union, and therefore the majority of the staff want to be in a union or are in a union.
Yeah.
So the employer just says, you know what, we'll recognize Unite voluntarily for collective bargaining purposes, and then that the issue about trade union access goes away because we're preemptively
Yeah.
making that move. So all of those sort of things I would advise employers
Yeah.
to do, to audit your existing practice against what the potential for the law is,
Yeah.
and then you're prepared.
The event that we're going to do
Mm.
end of May is going to be called Good Jobs, Better Business, question mark. And it's an exploration of when we do create good jobs, does it lead to better business?
Yeah.
And when we do anything like this, I guess what we should be hoping for,
Mhm.
and the vision should be that if we're doing all this stuff for the employees, it's creating a better experience of work for them. It should lead to higher levels of engagement, higher levels of productivity. Is that what you would anticipate?
Yeah, I mean that's the underpinning theory. So, engagement, productivity, retention, quality of work, less sickness absence, all of the things that employers want to do
Yeah.
and want to have in their organization, but prompted by a legislative floor and codes of practice to allow it to happen. Because there can be no denial that employers will say, well, yes, I want a better engaged workforce, and I want less sickness
Yeah.
absence, and I want more productivity,
Yeah.
and I want people to be more engaged.
Yeah.
Where's the loser in that equation?
So what we're looking for is a win-win here. We're looking for a better experience of work and relationship with work for the workforce,
Absolutely.
and the result being better performing businesses.
Absolutely.
That's the goal.
Absolutely.
Okay. And in terms of the LRA, then, you've got the experience, you've 50 years of engaging with employers, all these bodies, employees, you've got all the expertise there. You also engage then internationally as part of, a collective.
Yeah, we're part of the International Industrial Relations Agencies. So we have partnership or relationships with our counterparts in the South, which is the Workplace Relations Commission. We have a relationship with ACAS across the water for the rest of the UK. Okay. But we'll also have a relationship with Federal Mediation and Conciliation Service in the United States, the Canadian Industrial Relations Board, the Australian Fair Work Commission, the Employment Relations Authority in New Zealand. So there are 8 bodies, and we will share practice. We have an annual conference. We share practices around contemporary themes about everything from legislative reform through to the use of AI, and it's a brilliant chance to get a global snapshot of what's happening around the world in our respective jurisdictions in the world of industrial and employment relations, and learn lessons from one another about what works and what doesn't work, and it's invaluable.
Yeah.
And even though we're comparatively small, compared to our counterparts, for example, in Australia, there are things that we can demonstrate. For example, the engagement forum as a form of social dialogue that they can learn lessons from. So that international sharing gives that sort of global snapshot about, are we punching above our weight, for a small, jurisdiction? And invariably we find we are, but it's great to have that, sharing between my 7 counterparts around the world.
And you're learning lessons from maybe things that have already happened, and you're able to adjust for what we do here. So, but I guess at the end of the day, the takeaway is, if you are worried about this, reach out to the LRA, have a chat, get some advice, and
call our Workplace Information Service.
Okay.
Go onto our website. Independent, impartial, free,
so it's
and
free,
confidential.
right?
It's free of charge. It's a public
Yeah.
service. We're there to help employers and employees without passion or prejudice, without fear or favor, without making a distinction between what background you come from in terms of trade union or employer, regardless of the size.
Well, look, Mark, thank you for coming on the show.
You're very
I think that's been a great precursor for what we're going to do in May.
Absolutely.
And we've really, we've probably scratched the surface of what we could talk about. So we'll go even further, and we'll look at this from all the different viewpoints with all the different stakeholders who are going to come and speak at the event in May. If that sounds like an event that you want to be at, there is a waiting list for that. So please do get in touch with me. We will have limited capacity. Drop me an email to craig@vibranttalent.co.uk and let me know if you want to attend. Mark, if people are thinking, I do want to reach out to the LRA, is the best place to just go to the website? Or
just go to the website, www.lra.org.uk, and you'll find the link to the various things around the Good Jobs Bill, podcasts, documentation, or the phone number to speak to one of our employment advisors.
Brilliant. Okay. Thank you very much.
You're very welcome.
Good conversation. I've learned a lot. There's so much more that I could ask, but we'll get to that in May.
Absolutely.
Thank you to everybody who's tuned in. I hope that you found that to be informative. I hope you found it to be helpful. If you have enjoyed the episode, I would appreciate if you would give it a 5-star rating, a follow, and a share on social media, so that we can get these stories out to as wide an audience as possible, and together help to shape a better working world. That's it for this time. Thanks for listening.